My name is Hasan Davis, Deputy Commissioner of Operations with the Kentucky Department of Juvenile Justice with operational responsibility for all residential facilities. My comments today are based primarily on my professional work in juvenile justice and my personal experience in the juvenile justice system as a child. Kentucky has not always done what's considered in the best interest of youth when they come in contact with our system. 3 years ago, we were in danger of being out of compliance with the deinstitutionalization of status offender core requirement of the JJDPA. Due in large part to the misuse and overuse of the valid court order exception to DSO, allowing judges to place status youth, runaways, truants, and curfew violators in locked facilities. In 2007, the valid court order exception to DSO had been invoked in Kentucky almost 2,000 times, allowing judges to order locked detention for non-delinquent youth. To put that in context, for the same year, almost half of the states reported that less than 250 valid court order exceptions existed. Only 3 states had more than 1,000. In response, Kentucky had to make a choice: forsake the JJDPA and the protection it provides our youth, or challenge ourselves to do better. I'm proud to say we decided to take the challenge and to make better use of our facilities to meet the unmet needs of status offense youth without placing them in locked facilities. Sadly, youth of color and girls continue to be disproportionately affected and are more likely to be detained in status offenses than their white or male counterparts. To address our challenge with DSO, Kentucky State Advisory Group allocated formula grant dollars to pilot a Detention Alternative Coordinators program. After success, the Department of Juvenile Justice committed resources to expand this program, and today we provide alternatives to secure detention through the dedicated work of detention alternative coordinators housed in each of our 9 secure residential detention facilities. DACs partner with the Administrative Office of the Courts to educate attorneys and judges on resources in the community. After courts approve eligible youth for alternative placement, the DACs complete a risk assessment, match these youth with appropriate supervision and restrictions, and facilitate their transfer from secure to non-secure custody. The positive impact of our DACs is illustrated in Vicky's story. Vicky was a habitual runaway, climbing out of a window, walking away from school, regularly using drugs, and coping with a diagnosis of oppositional defiant disorder. Vicky wanted to disappear from school, from home, from the eyes of the world. She was picked up, and the DAC requested that she be diverted to an electronic monitor. During her placement, Vicky was ordered into treatment by the court and began needed prescription medication. As a result, school attendance became more regular, her grades began to improve, and today, Vicky is a college student at Eastern Kentucky University, in control of her life and living drug-free. There are times when locked detention is the only reasonable option to address a youth's delinquent behavior, but status offenses generally do not meet this threshold. With this in mind, I respectfully make the following recommendations regarding the Congress's reauthorization of the JJDPA. First, eliminate the valid court order exception to the DSO. This critical change received bipartisan approval by the Senate Judiciary Committee. If passed into law, judges would no longer be able to lock up non-delinquent youth out of frustration or a misguided sense of protection. The VCO exception was introduced in the 1980 reauthorization of the JJDPA, leaving states to sort out the sanctioned judicial use of locked detention for status youth. Too often, however, the exemption has swallowed the rule. Each year, nearly 40,000 status offense cases still involve locked detention. More than 30% would be prohibited if the VCO exception was removed from the JJDPA. In Kentucky, the DACs are addressing these challenges every day, and we believe that our state could serve as a model. There are alternatives to locked detention that create positive outcomes for youth and families, many of which may be supported by Title II formula grant program monies from the JJDPA. My second recommendation is that the committee consider ways it can strengthen the Act to support the efforts to refine and expand best practices in delinquency prevention, intervention, and treatment. Issues that the states are most interested in are meeting the needs of runaway and unaccompanied youth within healthiest and least restrictive environments, effective approaches for girls who are overrepresented among status youth, innovations to guard against bias and racial ethnic disparities, proactive truancy prevention, reducing school referrals to law enforcement, and effective positive family engagement strategies. Finally, I urge the committee to use the JJDPA reauthorization process as a vehicle for recovering and strengthening support to the states to achieve goals and purposes of the JJDPA itself. Since 2002, juvenile justice appropriations to states that support important priorities under the JJDPA, such as a continuum of services and care, alternatives to detention, and gender-specific services, have fallen by more than 50%. Here again, you have the opportunity to restore research, evaluation, and funding resources, as well as training and technical assistance resources needed to meet critical needs for girls and other children involved in the courts. You'll find these recommendations in keeping with the best practices and with the recommendations of the Coalition for Juvenile Justice and Association of JJDPA state advisory groups, as well as the broad-based Act for Juvenile Justice campaign that includes more than 350 organizations in juvenile justice, law enforcement, youth and family services, child welfare, mental health and substance abuse treatment, and representing many faith communities, among others. In closing, I wish to avail myself, if you should have further questions, I'd like to thank you for the opportunity to speak to you today. It has been my honor.